it's not a problem. I can talk anyway.
Mm.
So first of all, I would like to give a short introduction about the background in regards of the ongoing copyright reform in South Africa. So there are two main acts. It's first of all the Copyright Act and the Performance Protection Act in South Africa that are getting reformed in these days. And the Copyright Act is from 1978 and the Performance Protection Act is from 1967. So they are from a time where South Africa was under a regime in apartheid. So it's these are really old acts that definitely need to be reformed. And in mid-2015, there's been the first draft of the amendment bills. So it's already 7 years ago. And so you see, or alone from this background, you can see there has been huge discussions about this reform, and in particular about access to information, access to knowledge, and about the remuneration of authors. So after the acts have been approved by both chambers in South Africa, so from the National Assembly and the National Council of Provinces, the acts have been sent to President Cyril Ramaphosa, and according to section 79, paragraph 1 of the Constitution, the President of South Africa either has to sign the bill into law, or if he has reservations about the constitutionality of the bills, he refers it back to the National Assembly to reconsiderations. And this happened on 16th June 2020. Besides from formal reservations, he claimed the bill may constitute retrospective and arbitrary deprivations of property in regards of the remuneration of authors, and especially in particular, he had reservations about the fair use clause. We will talk about it later. And he also stated that some provisions are not aligned to international treaties. So this is just for to introduce you into the ongoing discussion about the reform. So let's talk a bit about the objectives of this reform. First of all, as I mentioned, these acts are from the 19th century, from the 20th century. So first of all, they want to align copyright with the digital era, and besides that, the legislator wants to implement access to knowledge in general. So access to knowledge is kind of a buzzword, or buzzwords in general. There are many problems in regards of people with disabilities. They don't have enough access to information, especially blind people. And in these cases, the legislator implemented provisions to grant this access to knowledge, especially for blind people. Furthermore, they want to align copyright law with international treaties, just to mention the WIPO treaties or the Marrakesh Treaty. And this is not just about the Copyright Act, this is also about the Performance Protection Amendment, the Performance Protection Act, but in this case, it's more about the protection of performers' moral and economic rights. Let's continue with the purposes of this of the act, of the bills. First of all, they want to protect economic interests of authors and creators against infringement, but also want to guarantee the reasonable remuneration of authors. Also, there's a new provision about access to and use of copyright works and access to information for education. So the legislator implemented many exceptions of copyright. Also, they want to promote accessibility to producers, users, and consumers in a balanced manner. So it's not just to give a bigger access to information or to knowledge, but also to guarantee or to balance these interests of the parties. So how does the legislator implement these purposes and these objectives? First of all, I want to highlight Section 6A of the Copyright Amendment Bill. It's about the share in royalties regarding literary or musical works. There are also provisions for audiovisual and visual artistic works in 7A and Section 8A of the Copyright Amendment Bill. Here, I want to highlight paragraph 2 of Section 6A. And it says that the author shall, subject to any agreement to the contrary, be entitled to receive a fair share of the royalty received for the execution of any of the acts contemplated in Section 6. Section 6 is about the exploitation of the copyright works. So this section says that every author has a right to reasonable remuneration in regards of royalties. Paragraph 3A also requires a written agreement. So the fair share must be determined in a written agreement. And furthermore, in paragraph 4, if the parties cannot agree on the author's share of the royalty, either party may refer the matter to the Copyright Tribunal for an order determining the author's share of the royalty. So this also bears some conflict in this case, because the Section 6A doesn't say anything about how to determine the fair share. So what is the fair share actually? And when there's a conflict about determining fair share, the parties have to call the Copyright Tribunal, and the conflict is actually moving from the parties to the Copyright Tribunal, and but the section doesn't say anything about how to determine or opens up the criteria about the fair share. So this might bear some conflict in this kind. It's not a real solution. About royalties for authors. So also a big change in copyright law in South Africa are going to be Section 12A, of the Copyright Amendment Bill, and this is the implementation of a fair use clause in South Africa. The fair use clause is a provision from US American copyright law, and it says that fair use in respect of a work or the performance of that work for purposes in according to Section 12A, paragraph A, the whole list of purposes does not infringe copyright in that work. So the list is about research, private study, or personal use, and including the use of a lawful copy of that work at a different time or with a different device. Also about scholarship, teaching, and education. So it's a really broad exception from copyright, and it is compared to a restrictive copyright law as we have it in South Africa right now. It's a big step into open up this restrictive system. So Section 12A also is a general exception, and it's in addition. So in Section 12A, paragraph A, it says in addition to uses specifically authorized fair use of that copyright work does not infringe it. So it's not a lex generalis clause. It's just an additional exception from copyright. Furthermore, the legislature implemented Section 19B. It's a general exception regarding the protection of computer programs. So a person having a right to use a copy of a computer program without the authorization of the copyright owner to observe, study, or test the functioning of the program in order to determine the ideas and principles which underlie any element of the program, if the person does so while performing any of the acts of loading, displaying, executing, and transmitting or storing the program. So here we have a clause or a section to get South African copyright law into the digital era, because before there was no exception in regards of computer programs, and we all know it's desperately needed because so many copyright works are created on computers, applications, or other devices, and also it's really valuable in regards of the economy. So the problem here is with this section, this is just about computer programs. So according to Section 2G of the Copyright Act, it's just programs that are stored on or programmed on a computer, and it's not about smartphones or tablets. And so we will see what the courts may decide in these cases when a computer or when an application is on a smartphone is created or is used as a copyright work. So maybe there will also be some conflicts about applications or smartphone uses. And the last clause I want to talk about is Section 19D. It's a general exception regarding protection of copyright work for persons with disability. I mentioned it in the introduction. that the legislature want to open up the use of copyright work for people with disability. For them, obviously, it's really important to, especially for blind people, to have an accessible formal copy of educational materials or of books in general, just to read them. And in Section 19D, the legislature implemented this kind of exception for copyright work. So a person with disabilities or a person who serves a person with disability may, without the authorization of the copyright owner, make an accessible formal copy for the benefit of a person with a disability. Yeah, so in conclusion, I want to say, I guess, this reform is a big step forward to open up this restrictive copyright law in South Africa that we have right now. We have many exceptions, especially fair use is really important in this regards. And besides that, many details are not determined yet. So the courts will be in charge to decide and to determine the details. But in general, I guess it's yeah, it's just a big step in the right direction.
So thank you very much. One last question.
Yeah.
What do you think, when will the change come into force?
Yeah, this is an interesting question, as I mentioned. The reform, or the discussions about the reform, are now 7 years and going. But as it seems like that the acts might be enforced in the end of the year, but it's not clear yet. But you can follow actually the legislative process. Probably we can share a link in the description of the so you can follow the process. And it seems that it's coming to an end, but we don't know yet. We don't know when it finally